Have you ever wondered if you can say or display anything you want, anywhere you want, especially when you are on someone else's land? It is a common question, and understanding the answer helps us navigate our rights and responsibilities in society. The fundamental protection for free expression, primarily found in the First Amendment of the United States Constitution, generally applies to government action, not private action. This means your right to free speech primarily protects you from censorship or restriction by federal, state, or local government entities. On private property, the owner typically has the right to set rules about expression, which can be more restrictive than what the government could impose. This distinction stems from the concept of state action doctrine. The First Amendment, like most constitutional amendments, acts as a restraint on government power. Private property owners, whether individuals or corporations, are not typically considered state actors. Therefore, they are usually free to regulate speech on their premises as they see fit, as long as they do not violate other laws, such as anti-discrimination statutes. This allows a business to establish a dress code or a shopping mall to prohibit political protests within its walls. So, how can you navigate this? If you wish to express yourself on private property, it is always wise to seek permission from the owner or management first. Understanding their policies in advance can help prevent misunderstandings. For example, some private universities might allow certain forms of peaceful protest on their grounds, while others might restrict it. Likewise, a private social club can enforce rules regarding attire or topics of discussion that a public park could not. There are a few limited exceptions to this general rule, which are important to recognize. For instance, in some states, particularly California, large privately owned shopping centers are sometimes treated like public forums for free speech purposes due to their quasi-public nature. This is often referred to as the Pranayar Doctrine, originating from a significant Supreme Court case. Additionally, if private property is dedicated to public use, such as a private road that is open to all traffic, free speech protections might apply more broadly there. Ultimately, the scope of free expression on private property largely hinges on whether the property owner acts like the government, or if the property is so open to the public that it serves as a functional equivalent of a public space. By knowing this key distinction and respecting property owners' rights, you can better understand where your constitutional protections against government censorship truly begin and end, ensuring harmonious interactions while still advocating for your views in appropriate settings.